and I'm a staff attorney with Project Sentinel. Um, we are a fair housing agency, and we're a part of the Renters Helpline. We process any kind of housing discrimination complaint, and we investigate them. So any kind of call, not just about no, if you have calls about your tenant landlord rights and fair housing issues, all of that can be accessed through the Renters Helpline number. So these are all of our services. And the thing to note here is obviously every one of them is free. Anyone who makes any decision related to giving housing, selling housing, renting it, regulating it, they all have to follow fair housing rules. So this briefly is the fair housing formula. This basically says that any kind of housing decision becomes prohibited if the decision there's a if the decision is consciously made based on someone's membership in a protected category. So there doesn't have to be, you don't have to have ill will, you don't have to have discriminatory intent. The only thing that has to happen for something to be a fair housing issue is a housing decision is made on the basis of a protected category. So you can't advertise based on a protected category, refuse to rent people based on that category, treat them differently based on a protected category, harass or evict them based on a protected category. And obviously this is just a brief list of the million housing decisions that are made. And even like statutes, like we talked about earlier, like housing authority, local governments, they make a lot of decisions related to selecting people who can live in housing. Even those decisions, again, have to follow fair housing rules. Is race and color. So you can't refuse to rent people because they're African American, refuse to grant repairs to Hispanic tenants, refuse to return the deposit of an Asian tenant. So another protected category is national origin, and that's where a person originally came from. It includes their customs, it includes even their cooking. So if you can infer that a housing decision is being made based on where someone came from, again, that's a form of housing discrimination. So let's say that someone is being charged a higher deposit because the landlord believes their cooking will stick under the walls. That's a possible fair housing issue based on national origin. This is disability, and these are for federal protected categories. So this includes both mental and physical disability. Again, no housing decisions can be made because someone is disabled. And also a protected category, again, no housing decisions can be made because of someone's religion. And that includes, their practice, their dress, but sex and gender also protected under both federal and state rules. See, this is an example here of something that might impact persons who are members of a protected category more than others, a policy. So let's say you have a policy that is, a noise policy, but it turns out that the noise was because of a domestic violence incident. So HUD has established that since HUD has placed this as a kind of sex gender issue, because this kind of policy, evicting people who are on noise complaints based on, but the noise complaint turns out to be a DV issue, that will impact more. HUD has found through their research that DV is an issue that impacts more females, and because of that, it becomes a situation where if there's a eviction based on a possible noise complaint, but the noise complaint is a DV issue, becomes a possible action based on sex and gender. These here are possible criminal and civil law issues, but they also impact fair housing, and you can also gain damages from these kinds of cases if you file a fair housing case related to sexual harassment in housing. So if there are issues of landlords refusing repairs unless they get sexual favors, or saying like rent in exchange for sexual favors, that is quid pro quo, kind of like in employment cases. Hostile environment is also a concept that fair housing law borrows from employment, where if there is sexual harassment going on or harassment on the basis of any kind of protected category going on, and it becomes so unbearable for the tenant, whether it's the landlord or neighbors doing it, that's something of a fair housing issue that feels status. And again, this is another status that is not as well known, but has these same protections as race and color, because it's a protected category. To be direct, someone can say, I don't want to rent to families with children. I am not giving repairs to families with children. But it can also be a bit indirect and maybe not even discriminatory on its face. So when you analyze a rule like an occupancy limit says that you can only have one person per one bedroom. Like the rental rule is only one person per one bedroom. That rule, when you look at the effect of that rule, and fair housing rules also protect against the effects of rules. That rule is going to have the effect of denying all applications from families with children. So a family with a parent with a child, two parents with a child, they will never be able to rent that room. And because fair housing rules do look at the effects of rules, that becomes a fair housing violation because it affects families with children. Story is source of income. And this, again, this is a protected category under state rules. Now, because voucher holders are protected and a voucher is a source of income protected under fair housing rules, you can't have ads that say no Section 8 allowed is citizenship and immigration status. It includes all status types as well. Even persons who are undocumented are protected by state fair housing law because citizenship and immigration status is a protected category under California law. All of this cannot be done based on a protected category, like we talked about. Description of what we look at when we investigate fair housing cases. Obviously, the gold standard for finding a case are words and documents. So if we can show that the landlord made his housing decision based on race, through their words, based on documents, they have rules that say children cannot play outside, that is direct evidence, and that shows a clear fair housing issue. But most often, we do not see that. That doesn't mean that we stop our investigation there. That just means that we have to do further investigation where we try to compare. So let's say we're seeing a situation where Hispanic tenants are not being given repairs in a complex, and we want to find out if that's true, if it's based on race or ethnicity. What we do in that case, if we don't have direct evidence, we don't have a landlord saying, outright saying that they're not giving repairs to Hispanic tenants. What we do is interview tenants at that complex and see how they're being treated. So if there are other Hispanic tenants and they're saying that, yes, we are not being given repairs, that's how we take the second step there, and we do interviews. If we have a place that we believe is not renting to Section 8 voucher holders, we do tests. Tests are what they are. Tests are, experiments that we do. We send over 2 testers who we've trained, and they apply to rent for a property. One says that they have a voucher, the other says that they don't, and we compare how they're treated. So right now we're just going over these situations where there could be possible fair housing issues. Protected, again, you can't use a protected category to do any of these things, to make any of these decisions. Refusing to show a place, evicting someone, steering is an interesting example because it just shows that you don't have to have discriminatory intent to violate fair housing rules. You just need to make a housing decision based on one of these categories, even if there is a good intent. So steering, let's say there's a 3rd floor unit that is available, there's a 1st floor unit that is available, but the property manager says families with children can only rent on the 3rd floor because it's safer. So there's good intent there, but the law doesn't really look at that good intent and says, well, you have good intent, you can discriminate. The only thing that the law looks at is, well, you used the fact that they have children to make a housing decision. That's housing discrimination. So other situations of where fair housing issues we've run into these situations before, investigated them before. So higher rent for one group vs another, slower no repairs, higher deposits. So comparing treatment and seeing if there's a pattern of treatment based on protected categories. It's important to remember that if something is said or written down, that writing or that statement is also a fair housing. It's just a standalone fair housing issue. So you could have refused to rent to someone because they're African American or because they're Hispanic. But if you also said it at the same time, those are two cases. So one is refusing to rent, the other is saying the harassing or discriminatory statement. So someone says, we're not renting to African Americans. Saying that in and of itself is a fair housing case. It's two fair housing cases because you just decided not to rent, which is a refusal to rent case. And the second thing that was wrong was a discriminatory statement. And that's another case under fair housing rules, using to grant reasonable accommodations. So reasonable accommodations are just requests from persons with disabilities who would like to have a rule changed. And there's a lot of these things. So closer parking spaces for persons with mobility related disabilities, support animals for persons with mental disabilities, changing a rent due date because someone's disability check arrives on the third Wednesday of the month instead of the first day of the month. All of these are rules that can be changed on the request of a renter who is disabled. That is not going to cost the landlord much. In most cases, it doesn't cost them anything because all you do is change the rule. So those are examples of reasonable accommodation requests, like common examples that we see all the time. All you do is connect a disability related reason to to a rule change, is refusing to grant a reasonable modification. So these modifications, they're things built into the unit. Not like accommodations where they're just rule changes or things that are not going to cost as much to build. These require some type of investment. So putting in a ramp, putting in shower bars, soundproofing, these are going to require some costs on the landlord to build something into the structure. So with these requests, again, the worst response to this is not to answer them. But if they are granted, most of the time, the tenant is going to have to foot the bill for these things. So the ramp, the shower bars, soundproofing, tenant has to pay for these unless the property is, unless there was like some types of federal funding that was used to build the property. If that funding was used, then maybe the owner of the property has to pay for the modification. But in the vast majority of times, it's the tenant that pays for the reasonable modification. The landlord can even require the tenant to restore the property in its former condition after they've moved out. So just remove the ramp, shower bar, soundproofing, if the tenant with a disability has moved out. Retaliation is another prohibited act. So if someone exercises their fair housing rights, let's say that it hasn't even been proven, they feel like they're being discriminated against, they write a letter to the landlord and say that, I feel like I'm being discriminated against based on race because of this type of treatment. If the landlord turns around, looks at that letter, responds and says, well, I'm going to give you a rent increase, or tries to make moves to evict that tenant, that kind of pattern there is retaliation and actionable under fair housing rules. And that's also a prohibited, that's the last of the list here of the prohibited acts under fair housing.